Welcome everybody to our legal update presentation series. Today I'm going to be talking to you about some interesting new case law that has emerged over the past few months, as well as some legislative developments. It's a lot to cover, so we'll try and go through it fairly quickly. The first thing we're going to deal with is the interesting case law, case law that I in any event have found to be quite interesting. One of the cases that we will deal with is the Willow Acres Home Owners Association and Mwale Busisiwe. This is quite an interesting case. It doesn't seem to have been reported, but nevertheless it still retains some value for us to know. To go through the facts fairly quickly, Mrs. Busisiwe was a single mother of 2 children and the registered owner of a property falling within the Willow Acres Homeowners Association. Now you all know what a homeowners association is. It is an association that is designed to protect the interests of residents living in a certain specified area. As a homeowners association member, you do have to pay monthly levies to the homeowners association. Miss Busisiwe unfortunately fell into arrears with the monthly account with the homeowners association. The result was that they issued summons against her for an amount of approximately 18,845 rand. She did not defend the action for whatever reason, and the result was that a judgment, we call it a default judgment, a judgment was entered against her. They then executed the judgment. You know, as when you obtain a judgment against a person for a sum in money, you then have to execute that judgment to obtain payment of the money. What you do is you issue what they call a writ of execution. The warrant is then served by the deputy sheriff who attaches goods to the value of the amount owing, and those goods are at a later stage sold in execution. But in this case, the sheriff advised that there was no property that could be attached to satisfy the judgment, and in addition that the Willow Acres property was a vacant plot. When the Homeowners Association was informed of this, they decided to institute proceedings to sequestrate Ms. Busisiwe. The sequestration application, though, was served upon her in Mamelodi, where she was then living. Unfortunately, it seems that Mrs. Busisiwe again failed to file a notice to oppose the application, and the result was that a provisional order of sequestration was granted against her. She did, however, file the notice of intention to oppose some 3 months later. In the opposing affidavit that she filed to oppose the sequestration order, she said that the application that had been obtained, that the judgment that had been obtained against her was on default. But she pointed out that had she been aware of this matter, she would definitely have defended the same, and for the following reasons. She said that the Homeowners Association had in many instances debited her with duplicated amounts for various expenditure items. She gave proof in her replying affidavit that, for instance, they had charged her over and over and over again for an item cutting the grass. She said that monthly building penalties had been imposed, that interest on arrears had been imposed, that untaxed attorney's fees had been added to her account, and that all these amounts had been included in that sum of 18,845 rand. The Homeowners Association did not deny that they had levied these extra charges, but they said they had done so in accordance with the Memorandum of Incorporation. The memorandum did not, however, permit the duplication of charges, the levying of onerous rates of interest, and demand for payment of untaxed attorney's fees. When the court considered the matter of the sequestration of Ms. Busisiwe, the court did find that duplicating of debts borders on the verge of dishonesty or overreaching. Now, this gives a very clear message to estate agents that one does not duplicate debts, because this does border on the verge of dishonesty, of overreaching. A very, very clear finding made by the court. The court held that the Homeowners Association was required to act not only in its own interest, but also in the interest of all members. The court found, therefore, that overcharging members, that is, members of the Homeowners Association, represented a breach of the fiduciary duty that the Homeowners Association had to its members, and that this conduct was certainly frowned upon. Ms. Busisiwe contested the amount, that amount of 18,845 rand, on the basis that she had been overcharged and overreached. And the court also found that there was what they called a whiff of dishonesty or overreaching. A whiff of dishonesty is something that no estate agent wants to have levied against them. So one has to be very, very careful. The result was that the provisional order of sequestration against Ms. Busisiwe was not confirmed. It was discharged, and the court, in showing its displeasure at the method approached by the Homeowners Association, actually made an award of costs against the Homeowners Association. As a result of all that, what is the message for estate agents? It is essential, bearing this case in mind, that estate agents, body corporates, homeowners associations exercise great care when debiting clients, unit owners and members. They must avoid duplicating items, charging onerous rates of interest, or debiting untaxed legal costs, as doing so may be perceived as overreaching, and this would have resultant negative consequences. So that is that one case of Ms. Busisiwe, which tells us that one, as an estate agent or as a body corporate or as a homeowners association, must exercise great care when compiling amounts that are owing or allegedly owing by members of the homeowners association or by any other person. The next matter that we're going to look at is that of City of Tshwane Metropolitan Municipality and T. Matabate. And this concerns something that has come very much into the limelight of late, the interpretation of Section 1183 of the Local Government Municipal Systems Act, as read with Section 1181 of the Act. Now, the question that arises is, what is Section 1183 as read with Section 1181? I'm sure that many of you watching today will know exactly what I'm talking about. The section indeed provides as follows, and let's see what the section does say. A registrar of deeds may not register the transfer of property except on production to that registrar of deeds of a prescribed certificate. You will all know that this is the so-called clearance certificate that must be issued and must be produced before transfer of a property can go through. So that certificate, that clearance certificate, is issued by the municipality and certifies that all amounts that became due in connection with that property for municipal service fees, surcharges on fees, property rates, and other municipal taxes, levies, and duties. Now, this is important. During the 2 years preceding the date of application for the certificate have been paid in full. So basically, the certificate confirms that all municipal rates, taxes, and any other amounts owing to the municipality for the previous 2 years, calculated as from the date of application for the clearance certificate, have been paid in full. The clearance certificate that is issued is then expressed to be valid for a period of 2 months or 60 days from the date that it has been issued. An amount due for municipal service fees, surcharges on fees, property rates, and other municipal taxes, levies, and duties is a charge upon the property in connection with which the amount is owing, and enjoys preference over any mortgage bond registered against the property. In other words, the municipality has a very clear right to execute against that property to recover any municipal fees, surcharges, rates, taxes that may be owing to the municipality. Now, in this case, in 2010, Mr. Matabate was the owner of a certain property in Cosmos Dal, and he appointed Nedbank, who was the holder of the mortgage bond, to sell the property by public auction on his behalf. And Auction Alliance was then appointed by Nedbank to conduct the sale. Following that instruction, in December 2010, a public auction was conducted, and a certain Mr. Lawrence made an offer to purchase the property from Mr. Matabate for 1.3 million rand, and that offer was duly accepted, so there was a sale. Once the sale had been concluded, Nedbank instructed their attorneys to register the property from Mr. Matabate into the name of Mr. Lawrence. As they were required to do, the conveyancing attorneys applied to the Tshwane Metropolitan Municipality for the clearance certificate that we've been talking about. The municipality, when they get an application for the issue of a clearance certificate, investigate what amounts are owing by the property owner, and they will then issue a statement indicating how much needs to be paid for the issue of that clearance certificate. In this case, they advise that an amount of 162,722 rand was due, including an amount of 151,324 rand for what they termed historical debt. In other words, debt older than the period of 2 years prescribed in Section 1181 of the Act. The municipality was prevailed upon by the conveyancers to exclude that historical debt, and were advised by the conveyancers that they were only entitled to charge for the period of 2 years preceding the date upon which application for the clearance certificate was made. The application was opposed by the municipality, and in the event, the matter was heard by a court which upheld that view that the municipality could only levy a charge for the preceding period of 2 years as from the date of the application for the issue of a clearance certificate. The municipality appealed against that against that judgment, and this is the case that we are presently referring to. They said that the transferring attorneys, in requesting the historical debt to be reversed, had not taken notice of the provisions of Section 1183 of the Act. The appeal court held that municipalities are obliged to collect monies payable to them for property rates and taxes and for the provision of municipal debts. The appeal court also referred to the judgment of Judge Nugent in a matter of City of Cape Town versus Real People Housing Limited, where it was found that municipalities are assisted to fulfill the obligation to collect money that becomes payable to them so far as debts relate to fixed properties in 2 ways. They are given, as we have already seen, a security for repayment of the debt as a charge upon the property. We've noted that is Section 1183. They are given the capacity to block the transfer of ownership of the property until debts have been paid in the circumstances set out in Section 1181. So we can see Section 1181, as read with Section 1183 of the Act, provide the municipality with 2 different remedies. The purpose, though, of each of these remedies is to ensure the payment of the municipal claim. The security given to a municipality by Section 1183 represents a charge upon the property. It's almost like the municipality has a bond registered over that property, and it is a self-contained security provision. The courts, in the end of the day, found against the municipality. So what is to be learned from the facts of this case? What is to be learnt is that municipalities are obliged to issue a clearance certificate on payment of any amounts due for the two-year period preceding the date of application. But furthermore, that municipalities have a lien, it's almost like what they call a tacit hypothec over the property, and that no limit is placed on the duration of that lien or that hypothec over the property, so that a municipality enjoys preference over a registered mortgage bond on the proceeds of the property. Very, very interesting. So everyone was very happy and thinking that when you apply for a clearance certificate, you now only have to worry about the 2 years preceding the date of application for that clearance certificate. The waters were a bit muddied, and final determination was then given in another case, again involving the City of Tshwane Metropolitan Municipality, and in this case, a certain P.J. Mitchell. This case didn't turn out so well for buyers and sellers of immovable property as the Matabate case. So let's have a look and see what the difference is. This case was referred to the Supreme Court of Appeal, and again, the question was to interpret Section 1183 of the Local Government Municipal Systems Act. The court confirmed that a hypothec, a lien that we've already seen in the Matabate case, existed in favor of the municipality to secure all amounts owing to the municipality, and furthermore found that this hypothec or lien was not extinguished by the transfer of the property from the owner who incurred those debts to a third party, whether the sale was a sale in execution or any other form of sale. So what do we understand from this? We understand that a municipality may institute legal action against the present owner of an immovable property for all amounts owing by any prior owner of that property. Again, the municipality can institute legal action against the owner of a property for amounts that were owing to the municipality even before that owner took transfer of the property. The property that the owner bought and that the owner presently lives in or has stands as security for the debt that is owed to the municipality, regardless of who presently owns that property, and even if the debt was incurred by a person other than the present owner of the property. Should the previous owner of the property refuse to pay the municipality can apply to court to attach the property, which of course is now owned by somebody else, having been sold, and if and when, and probably likely, the municipality obtains judgment in the matter, they can sell that property in execution to satisfy the municipal debt, notwithstanding that the current owner of the property had nothing to do with the incurrence of that debt. So what it means is that the new owner can be held responsible for the municipal debts of the old owner for up to 30 years. Now, 30 years you say, but Section 118 only refers to a period of 2 years? The answer is Section 118 does indeed refer to a period of 2 years, but 30 years, in fact, is the period of prescription. In other words, a claim by the municipality only prescribes or only falls away, only becomes null and void after a period of 30 years has passed. So, notwithstanding the specific mention of 2 years in Section 118, the municipality can actually hold an owner of a property liable for debts incurred for a period of 30 years, which is quite harsh, but that is the law. A new owner could, of course, raise any defenses that the old owner might have raised in responding to the matter, but in many instances, and I think you'll find it in probably all cases, this is not really very helpful at all, simply because the new owner has no knowledge and would thus be unaware of the activities of the old owner and would not know what particular remedies are available. So, what is the result of this case? And let us emphasize this. Property owners thus now face a quite grim prospect of owing huge sums of money to municipalities in respect of municipal debts incurred by previous owners. The onus is now on conveyancers to ensure that all amounts required to obtain a clearance certificate in terms of Section 1181 of the Act, including all historical debts in terms of Section 1183, are carefully assessed, scrutinized, and settled in full prior to the transfer of the property into the name of a purchaser. This includes what we saw in the Matabate case as that historical debt of 157,000. Had the Matabate case been decided by this court, that 157,000 would have had to be paid. So, doing so will prevent the new owner from being faced with a dilemma of being held liable for by the municipality for historical debts incurred by the previous owners. So, there is a new onus resting upon conveyancers to ensure that they are aware precisely of all amounts that are required to settle any indebtedness to the municipality and that need to be paid before a clearance certificate can be issued. Purchasers should be advised of this by estate agents. Sellers should be advised of this by estate agents. And purchasers should then ensure that they ascertain from the municipality that the correct figures have been given for the issue of the clearance certificate, that the correct amount has been paid, and that they are not subsequently saddled with a huge debt that is owing to the municipality that was not incurred by them and for which their property can now be sold in execution by the municipality. That is the current law as it stands. Okay, so let's get away from that for a while and get on to another topic which is also of great interest and importance to estate agents, and that is the proper maintenance of trust accounts, the proper keeping of trust books, and the proper ensuring that books and accounts are properly audited and that everything is in order with trust matters. Trust accounts are supposed to be sacrosanct in the hands of estate agents, and a similar situation applies where attorneys are concerned. So the law where it applies to attorneys applies equally to estate agents. We looked at a matter of Heppel and others versus the Law Society of the Northern Provinces, which is a 2014 case, and the facts of the matter are quite interesting. Heppel, there were two people, Heppel and Earl, who practiced as attorneys in Pretoria under the name of Heppel Attorneys, and the Law Society, after a due investigation, uncovered a number of irregularities where the trust accounting of Heppel Attorneys was concerned. They found that there were substantial trust deficits in their books of account. They found that there had been a misappropriation of trust funds. Heppel had failed to account to the Law Society for interest generated from trust banking accounts. They had failed to keep copies of bank reconciliation statements, and there had been a manipulation of bank reconciliation statements. Now, estate agents who are listening to me will immediately perceive that the duties that are imposed upon an attorney are precisely the same as those imposed upon an estate agent. So immediately ears will have pricked up and they will have said, there's problems over here, and they will have been quite correct in saying that. Further thing was that they failed to pay interest earned on trust monies. This would normally be paid over to the Law Society. They had concealed trust deficits. They had failed to submit required auditors' reports. They had conducted an investment practice in which interest was paid to investors out of the trust account, creating a trust deficit, and they had failed to keep proper accounting records. They were struck from the role of attorneys, as could be anticipated, and Heppel attorneys, that is Mr. Heppel and Mr. Earl, appealed against the finding of the High Court, striking them from the role of attorneys to the Supreme Court of Appeal. I might be able to say quite convincingly that any estate agent who is found to have contravened these specific provisions of the Estate Agency Affairs Act, which are basically pretty similar to those of the attorneys, would in all likelihood also have their Fidelity Fund certificate withdrawn. What did the court find? That is the Supreme Court of Appeal. They found that there was a total lack of candor by Heppel and Earl in respect of the transactions they were involved. They said that the allegations made by the Law Society simply could not be brushed aside, as Heppel and Earl had tried to do. And furthermore, that attorneys must respond meaningfully and furnish full and proper explanations when requested to do so. The same naturally applies to estate agents. You cannot simply brush aside allegations of a failure to deal with your trust accounts in the proper manner, but estate agents, like attorneys, need to give the regulator, the Estate Agency Affairs Board, full and proper explanation when called upon to do so. Earl, for his part, seemed to have accepted some responsibility for these problems, but Heppel, on the other hand, did not do so. So I'm not going to go into too much detail where that is concerned. You can read that for yourselves. What eventually happened was, as we have seen, the High Court found that both Heppel and Earl were not fit and proper persons, and they were disbarred from acting as attorneys. Earl's conduct was dishonest and prejudicial to trust creditors. Heppel's moral culpability was not any less than that of Earl's, despite Mr. Heppel's endeavors to try and disassociate himself from the wrongs that had been perpetrated. The court found that he was just as liable for what had happened as Earl was. The High Court said that even assuming that he was presently practicing as an attorney employed at a firm other than Heppel Attorneys Incorporated, which is what he alleged, he was not handling trust monies, that's what he alleged, he could still not be entrusted to practice as an attorney at all. So Heppel seemed to have said, I am still practicing as an attorney, but I'm no longer going to be handling trust monies, therefore let me alone and leave me free to do my own thing. The court said, no ways, you are not fit and proper to practice as an attorney. One thing that the appeal court did note is that, of course, it's never easy to impose the ultimate sanction on an attorney. In a estate agent, the ultimate sanction would be with the withdrawal of a Fidelity Fund certificate. As with estate agents, imposing this ultimate sanction on an attorney has the effect of terminating that attorney's means of livelihood, and this certainly has adverse consequences, both the attorney and to their family and to everybody associated with that attorney. So the court said that before they can disbar an attorney, and the same would apply to an estate agent, they must be satisfied that this disbarment is the only possible solution to protect the public, particularly where trust funds are involved. Court found that Earl knew more than he was willing to acknowledge, and moreover that simply suspending Heppel and Earl would not be a practical solution and would leave an unsatisfactory result. They found that their conduct was dishonest, potentially prejudicial to trust creditors, and that both of these parties were equally to blame. They both were morally culpable. The appeal court therefore decided that they would dismiss the appeal and that the disbarring would be upheld. So the lesson that we learn as estate agents is that we fall into the same fiduciary position as attorneys, especially where trust monies are concerned, which I've tried to emphasize. Trust monies must at all times remain sacrosanct in the hands of estate agents. Remember, trust monies are not your monies. Trust monies are monies that have been entrusted to you by someone else and that you are holding in trust. It's not your money. You can't use that money. You can't spend that money. You can only pay that money out of the trust account when legally entitled to do so. An estate agent can never be heard to say that they had entrusted the responsibility of dealing with trust monies to other partners, members, directors, or even employees of an estate agency enterprise. We've had occasion where there have been trust shortages, and the estate agent has averred before one of our committees of inquiry that it wasn't me that stole the money, it was my bookkeeper, and therefore don't blame me, blame my bookkeeper. That is no valid excuse, and you cannot aver that the responsibility that is really yours as an estate agent was delegated to someone else. Moral culpability for the wrongs of an estate agency enterprise attached to all principles of that enterprise. If, therefore, there are a couple of partners or a few members of a close corporation or a couple of directors of a estate agency company, and one director does something horrible with the trust accounts, it is no excuse for the other directors to say either that they were not aware or that they had delegated the responsibility of maintaining that trust account to a certain other director. All principals will be held responsible. Let's get on to another matter, and this deals with the ever ubiquitous PIE Act, the Prevention of Illegal Eviction from an Unlawful Occupation of Land Act. I'm not going to go into this matter too much detail, but it has quite interesting facts. It's the matter of Pitcher versus Shibambo, and it's a recent matter that was only finalized this year. Mr. Pitcher was a 76-year-old gentleman in ill health, lived at the property which was his primary residence and home. In June 1992, the property was registered in favor of Pitcher's brother against a bond in favor of Nedcor Bank for a purchase price of 14,000. In other words, Pitcher had sold the property to his brother for 14,000 Rand, and Nedcor Bank had financed that purchase. During 2001, some 9 years later, the brother experienced financial difficulty. Nedcor sought to sell the property in execution since the brother had fallen into arrears with the bond. Following negotiations between Nedcor Pitcher and his brother, Pitcher agreed to take over the bond payments and entered into agreement of sale, in terms of which he repurchased, I should imagine, the property from his brother for 73,000 Rand. There was a normal clause and suspensive condition relating to the grant of a bond finance to cover the purchase price. So you can read that on your own. Pitcher alleges that he made payments to Nedcor, but at some undisclosed point, he was inexplicably informed by Nedcor that the bond account had fallen into arrears and had been closed. The agreement between Nedcor and Pitcher indicates that at 12th December 2001, the bond amount stood at 52,069 Rand. Some 8 years later, innocents, Mr. and Mrs. Shibambo, purchased the property that was owned by Pitcher. They purchased the property for 380,000 Rand, and the deed of sale contained a handwritten clause which stated that eviction, if needed, will be done by seller on the seller's costs. Blue Glue, the estate agents involved in that transaction, I had undertaken to contribute an amount of 5,000 Rand towards the costs of an eviction if an eviction takes place. Needless to say, Mr. and Mrs. Shibambo were not able to take occupation of the property, which was occupied by Mr. Pitcher, and they launched an application out of the High Court to do so. Pitcher did not defend the application, and an order was granted by default. Although Pitcher had, in fact, filed a notice of intention to oppose, he had not followed that notice of intention up. What Pitcher then contended was that the sale between himself and his brother was valid and enforceable, and that Mr. and Mrs. Shibambo were not bona fide purchasers, and hence the transfer into their names was assailable. He alleged alternatively that Mr. and Mrs. Shibambo had not complied with the requirements of Section 4.2 of the PIE Act. The court, though, granted an eviction order. So what happened was, this case was then an appeal by Pitcher against the grant of an eviction order by the High Court. The High Court considered the PIE Act, and I think every estate agent needs to have some knowledge of the PIE Act to understand the contents of this case. But what does Section 4 of the PIE Act provide? It provides inter alia. If you have a look at Section 4.1, the important sections, notwithstanding anything to the contrary contained in any law or the common law, the provisions of this section apply to proceedings by an owner or person in charge of land for the eviction of an unlawful occupier. Section 4.2 says, at least 14 days before the hearing of the proceedings contemplated in subsection 1, that's what we've just read above, the court must serve written and effective notice of the proceedings on the unlawful occupier and the municipality having jurisdiction. Continues that if the unlawful occupier has occupied the land for more than 6 months at the time when the proceedings are initiated, a court may grant an order for eviction if it is of the opinion that it is just and equitable to do so. It must consider all relevant circumstances before doing so, including, except where land is sold in a sale of execution pursuant to a mortgage, whether land has been made available or can reasonably be made available by a municipality or other organ of state or other landowner for the relocation of the unlawful occupier, and including the rights and needs of the elderly, children, disabled persons, and households headed by women. So you will see that in certain circumstances, before an unlawful occupier can be evicted from property, there are certain definite legal requirements that must be gone through so that the order is valid in terms of Section 4 of the PI Act. The Court of Appeal found that the judgment of the High Court had not fully considered these requirements. Those are the requirements that we have just mentioned, merely noting that the default judgment had included an eviction order. The default judgment was therefore rescinded, for the simple reason that no consideration had been given to the issue of suitable alternative accommodation for Mr. Pitcher. You will remember Section 4 does provide that the question of suitable alternative accommodation must be investigated. The court held that the application of Section 4 of the PI Act is not discretionary, it's mandatory. Courts must consider the PI Act in eviction cases. The PI Act was enacted to ensure fairness in and legitimacy of eviction proceedings and clearly set out the factors that are taken into account by a court when considering the grant of an eviction order. Given that evictions naturally entail conflicting constitutional rights, these factors, that is the factors that are mentioned in Section 4 of the PI Act, are of great assistance to courts in reaching constitutionally appropriate decisions. Courts cannot merely restrict themselves to the passive application of PI Act and are obliged to probe and investigate the surrounding circumstances when an eviction from a home is sought, particularly when the prospective evictee is vulnerable. And in this case, we've seen that Mr. Pitcher was a 76-year-old man and in a very vulnerable position. This matter was accordingly remitted back to the High Court for reconsideration to enable that court to further consider the evidence and other argument which could be presented to justify an eviction under the PI Act. Insofar as the sale to the Shibambos was concerned, the court held that there was nothing wrong with this sale. The Shibambos were the owners of the property. They were entitled to seek the eviction of Pitcher from their property, but their standing as owners was not conclusive in the eviction order. Section 4 says that evictions must be just and equitable, and the Constitutional Court had not considered Mr. Pitcher's affidavit, which outlined his personal circumstances and the likelihood that he would be homeless if he were to be so evicted. The Constitutional Court concluded that the requirements of justice and equity had not been properly served by the High Court. Therefore, it is very clear that the courts take the provisions of the PI Act very, very seriously, and they apply those conditions. As the judge in the appeal court said, the Section 4 of the PI Act actually gives the court the grounds to consider. They are told what they need to consider, what has to be taken into account, and what factors must be satisfied before an eviction order can be granted. A lot of you will be dealing with evictions, and it is essential that you are aware of the conditions and the stipulations contained in the PI Act and comply very carefully therewith. Okay, so we'll move away from that and we're going to move into another case, auctioneering. Auctioneering, we know, has been in the limelight a lot of late, and the questions that have emerged in a number of cases is how do you distinguish what they refer to as ghost bidding at auction sales from vendor bidding? Vendor bidding, as we were going to see, is perfectly legitimate and acceptable. Ghost bidding, on the other hand, is not permissible and is in fact outlawed. This matter was actually dealt with quite recently in 2015 in the matter of Hansa Silver Pty Limited and others versus Obifon or the High Street Auction Company. So let's have a look at the facts of this case quickly and see what the court decided. In 2001, the Taba Puti Safari Lodge was sold for 20 million rand at a public auction that had been conducted by High Street to a Mr. Ichikovitz. Ichikovitz purchased the property for a company to be formed, Hansa Silver Pty Limited, and that's why we see that the applicant in the matter was Hansa Silver. In terms of the mandate, the sellers had appointed High Street to bid on their behalf at a public auction up to the reserve price of 25 million, and the following were the rules of the auction. These were the rules that were contained in the rules of the auction and which were presented to people attending the auction. Clause 3 said, unless otherwise announced, all lots are sold subject to a reserve price important, and to a 5-day acceptance period in favor of the seller. Unless otherwise announced, the High Street Auction Company and the auctioneer are entitled to bid on behalf of the seller up to the reserve price. The advert for the auction stated that the rules of the auction were available. We've seen what those rules said on a specified website as well as at the offices of High Street. Advertisement also indicated that all bids were subject to a minimum reserve and that the auctioneer had the right to bid on behalf of the owner. Ichikowitz registered as a bidder at the auction, signed the standard bidder registration form, and thereby acknowledged that he had read, understood, and was bound by the conditions of the auction. Those are the conditions we've just noted. Remember, unless otherwise announced, lots are sold subject to reserve price. Unless otherwise announced, the High Street Auction Company and the auctioneer are entitled to bid on behalf of the seller up to the reserve price. Those are very important clauses that were contained in the rules of the auction, and which Ichikowitz acknowledged he was bound by. The commencement of the auction, the auctioneer read out the rules and invited questions. No questions were received. Most of these auctions these days are videoed, so I had a look at the video that showed that bids had been made by one Dr. Hosseini and by Ichikowitz, interspaced by bids by the auctioneer on behalf of the sellers, quite in order, as we've seen in terms of the rules. All these bids were below the reserve price. Ichikowitz eventually was a successful bidder at 20 million rand. Ichikowitz and Hansa, remember the Hansa was the company that purchased the property, subsequently alleged that the price was reached due to sham bidding by High Street, sham bidding or ghost bidding. So Ichikowitz now took exception to the fact that the price had been driven up due to what he alleged was sham bidding. He then averred, both he and Hansa averred, that the sale should be void and that any commission paid should be refunded. This claim was dismissed by the High Court, and an appeal was made by Ichikowitz and Hansa, in which they relied on regulations 26.3 and 4 of the Consumer Protection Act. Now, what do those regulations say? 26.3 says the auctioneer must ensure that a person who intends to bid on behalf of another produces a letter of authority expressly authorizing him or her to bid on behalf of that person, and both that person and the person bidding on his or her behalf must meet the requirements of sub-regulation 2. 4 says the auctioneer must ensure that if a person will be bidding on behalf of a company, the letter of authority contemplated in sub-regulation 3 must appear on the letterhead of the company and must be accompanied by a certified copy of the resolution authorizing him or her to do so. Okay, now these regulations are, of course, regulations made in terms of the Consumer Protection Act, and we are going to consider what the Consumer Protection Act also says regarding auctions in due course. The appeal court, in considering these representations, held that regulations 26.3 and 4 had to be read with regulations 26.1 and 2. In terms of 26.1, the auctioneer must have a bidder's record for every auction to record the identity of all bidders at an auction, while regulation 26.2 provides that the auctioneer must ensure that every prospective bidder is registered prior to the commencement of the auction. The ordinary meaning of regulations 26.3 and 4 is clear, and the auctioneer must ensure compliance by prospective bidders. The court held that the reason underlying regulations 26.3 and 4 is to identify bidders to enable communication with the successful bidders for purposes of matters such as the delivery of goods and securing payment of the purchase price. In this context, the ordinary meaning of these provisions makes good sense. Everybody at an auction knows or could easily ascertain the identity and location of the auctioneer and the auction house where applicable. There are other provisions contained in Regulation 21.2b, but I'm not going to worry too much about those. Now, auction bids by or on behalf of a seller, that is what we call vendor bidding, must be distinguished, so the court held, from sham bidding or ghost bidding. In instances of sham bidding, bids are made in terms of an underhand arrangement to artificially raise the sale price, or a non-existent bid is represented as being a real bid. No doubt sham bidding is unlawful. In terms of the common law, vendor bidding is prohibited at auctions without reserve. Vendor bidding and bidding by and behalf of the auctioneer are, however, expressly, as I've said, recognized by the Consumer Protection Act. What do we see the Consumer Protection Act saying? And in this respect, all of you should have a look at Section 45 of the Consumer Protection Act, which deals with the question of auctioneers and how consumers are protected in their dealings with auctioneers. Contemporaneous identification of vendor bidding is not required by Section 45 of the CPA. Section 45.5 requires no more in this regard than that notice be given in advance that the sale is subject to the right to bid by or on behalf of the owner or the auctioneer. Regulation 21 deals with prohibited behavior of an auctioneer. Regulation 28, again of the CPA, contains provisions in respect of bidding, and neither requires identification of vendor bids. The practice thus accords with the position of other bidders. A bidder is not obliged, in fact, to identify him or herself when bidding. There's therefore no general rule that bids by an auctioneer on behalf of a seller had to be identified as such. The surrounding circumstances in this case show that vendor bids were adequately identified in any case. Whether non-disclosure of a vendor bid in any given case constituted a misrepresentation was a question that had to be decided on the facts and circumstances of each individual case. If the failure to identify a vendor bid as such constituted a material misrepresentation in the particular circumstances, an auction sale may, in terms of the general principles of contract, be avoided if the misrepresentation was both material and induced the sale. In response, High Street submitted that the auctioneer's bids on behalf of the seller were in fact identified as such in the context in which they were made. The court agreed with the submission after having regard to the similar bids that had been made by the auctioneer, which were clearly visible when they saw the video. The purchasers did not show, their purchasers being Mr. Ichikovitz, did not show that the auctioneer's bids on behalf of the sellers constituted a material misrepresentation that induced the sale or agreement. The rules of the auction made clear that the auctioneer was entitled to bid on behalf of the sellers up to the reserve price. The court found furthermore that Ichikovitz in this case was an experienced businessman who had in the past purchased several properties on auction, so he was pretty much aware of what happened at an auction. It is very unlikely that a person in his position and who had been made aware of the possibility of vendor bidding by the auctioneer would be misled by the vendor bids. Ichikovitz therefore had only himself to blame for ignorance of the possibility of vendor bidding. The appeal by the purchasers was thus unsuccessful. What this case tells us is that if an auctioneer engages in vendor bidding pursuant to the specific requirements set out in Section 45 of the Consumer Protection Act and complies with the regulations 26 contained in the Consumer Protection Act, there is nothing whatsoever wrong with vendor bidding. Vendor bidding will be upheld. There's nothing wrong with it, provided it is made public, provided it is announced, provided that people attending at the auction have registered, the bidders have registered and are aware that vendor bidders will be made up to an amount of any reserve price. It's not even necessary for the auctioneer to state what the reserve price is. He merely has to say that vendor bidding will be made up to an amount of the reserve price. Ghost bidding, on the other hand, is the fraudulent manipulation of the bidding process by an auctioneer or by persons placed in the audience by an auctioneer simply for the purpose of raising the price, and this is not only frowned upon but is a criminal offense in any event. And should auctioneers who are acting as estate agents when they sell immovable property engage in ghost bidding, they can look forward to an appointment before one of the EAAB's committees of inquiry, and I'm sure we'll have a lot of explaining to do. Thank you very much. Well, I hope that you've learned something from these court cases. What we propose now doing is having a look at some of the new legislative developments that are in the offing for 2016 and beyond, and having a brief look at how they are possibly going to affect the state agency sector and the professionalization of that sector. The first thing we're going to do is look at the Protected Disclosures Amendment Bill. A lot of protected disclosures are made, and people become very upset after these disclosures have been made to find that they have been deprived of the immunity that they thought they had. The Protected Disclosures Amendment Bill, in fact, indicates that there will be no blanket immunity for whistleblowers. Legislation guiding the National Prosecuting Authority in determining who automatically qualifies for immunity from civil or criminal liability when providing information of an alleged offense is examined in the consideration of the Protected Disclosures Amendment Bill, which seeks to facilitate and encourage the disclosure of unlawful or irregular conduct on the part of both public and private sector employers and employees, I should imagine. It is noted that in situations of alleged impropriety, the need to protect certain information, either in the national interest or in the interest of an employer's livelihood, militates against the granting of blanket immunity. So in fact, the idea of a blanket immunity for any protected disclosure or so-called protected disclosure seems to have been dispensed with in the amendment bill. Clause 10 of the bill does not introduce the grant of any blanket immunity from civil and criminal liability for whistleblowers, and the possibility of providing legal aid for whistleblowers is thus explored further. In other words, Clause 10 of the bill recognizes that a whistleblower may not receive an immunity and seeks to assist the whistleblower concerned who doesn't receive immunity by looking at possible ways to grant legal aid to that whistleblower. The bill is mindful of the reputational damage that can result from a disclosure, and Clause 10 of the bill also includes a provision that has since been quite rigorously debated, that criminalizes the making of intentionally false disclosures. We do have situations where disclosures that are false are intentionally made for ulterior motives. If this becomes a criminal offense, it will ensure that employees approach whistleblowing in a more responsible manner. Clause 4 of the bill provides that both the temporary employment agency and its client should be held jointly and severally liable in situations where an agency, and these are the words, under the express or implied authority or with the knowledge of a client, subjects an employee or worker to an occupational detriment following a disclosure about one or other party concerned. It is envisaged that independent contractors and consultants will also be brought within the ambit of the proposed act. Clause 4 of the bill seeks to ensure that a whistleblower is informed of the employer's decision on whether or not to investigate the disclosure concerned, as well as the outcome of any ensuing investigative process. This is a new innovation in the old legislation. Once a whistleblower had made a whistleblowing report, there was no obligation whatsoever to come back to that whistleblower or to apprise that whistleblower of what events would follow the making of that report or what had happened consequent to the making of that report. The new bill makes it mandatory for all employers to have appropriate internal procedures in place for receiving and dealing with information about alleged improprieties. So the law dealing with the making of protected disclosures and whistleblowing reports is going to be beefed up. In certain circumstances, it may be better for the whistleblower. In certain circumstances, it may not be so. We'll just have to see what happens when the bill is finally considered and passed into legislation. There's also a proposal to strengthen consumer protection measures that is in the offing in 2016. The Department of Trade and Industry believes that new measures should be introduced to strengthen the existing consumer protection mechanisms. The Trade and Industry Minister has alluded to the possibility of a coordinated, cohesive, and comprehensive consumer protection model that could be developed, and this model will be applied to the National Consumer Tribunal, the National Consumer Commission, the National Credit Regulator. These three agencies have been operating pretty much independently of one another, and the Minister feels that this has diluted the protection that they are supposed to afford consumers. The Minister believes, therefore, that the three regulators should combine their resources in addressing the plight of consumers in a marketplace increasingly characterized by credit affordability corner-cutting measures which are specifically aimed at improving sales. And if I say that this should resonate with estate agents and ring a bell with estate agents, I'm sure you would all agree with me. We are in a sector that is a commission-driven sector, and where sometimes measures are taken to cut corners, to get purchasers to sign on the dotted line without concern to the subsequent dangers that may lurk for that consumer. This is something that will certainly be looked at. The Minister has expressed the view that as a law of general application, the Consumer Protection Act should be implemented more vigorously. That is the Consumer Protection Act, our current legislation, to be implemented more vigorously and in concert with sector-specific legislation if consumer protection is to be strengthened. In other words, the Consumer Protection Act needs to be applied having regard to the provisions of the current Estate Agency Affairs Act to protect consumers, and of course to the Property Practitioners Bill, which will take due cognizance of the views of the Minister when formulating its consumer protection proposals. Another interesting development is to increase the cooling off period for auditors who have had long associations with their clients. I'm not going to harp on this too much, but just to note that the Independent Regulatory Board for Auditors has called for comment on their proposals to increase the cooling off period for auditors who have had long associations with their clients. The rest of this is probably very technical, so I don't intend going into it in too much detail. But if any person is interested in this matter, please refer to the IRBA website and more details will become apparent. So I'm not going to worry about that. Oh, another important thing is the introduction of cybersecurity and anti-corruption bills. It seems likely that a Prevention and Combating of Corrupt Activities Amendment Bill, as well as a Cyber Crimes and Related Matters Bill, will be introduced in Parliament during the course of 2016. Following the Protected Disclosures Amendment Bill, which we've just discussed, which seeks to improve the level of protection made available to whistleblowers, the aim of the Prevention and Combating of Corrupt Activities Amendment Bill is to address practical challenges and close gaps in the existing legislation. The draft Cybercrimes and Cybersecurity Bill, which has already been tabled in August 2015, sought to impose security-related obligations on electronic communications service providers, proposed a number of new structures for policing the electronic communications space, and spelled out circumstances in which a vast array of activities associated with it would be deemed to be criminal offences. These include computer-related fraud, forgery and uttering, appropriation, extortion, terrorism and espionage, promoting or inciting hatred, discrimination, violence or damage to property, and copyright infringement. So you can see it goes quite a long way. Another matter that has been occupying the attention of our legislators and of the EAAB of late is the need for the introduction of anti-racism legislation. We all know that there's been a lot of polemic surrounding the views expressed by certain estate agents, or I think they're not estate agents any longer, but certain persons who were estate agents, and this has led to a flood of public comment and to calls for action. The Minister of Arts and Culture, at a recent dialogue on developing a front against racism, postulated that, and these were his words, whilst we cannot regulate racial attitudes, a regulatory framework should be in place in the interim, particularly to regulate behavior and serve as a deterrent to would-be racists. The Minister emphasized furthermore that the time has possibly come to stop being reactionary, waiting for incidents of racism to flare up before decisively dealing with the issue. So what the Minister was saying is we need to be proactive in dealing with racism, eliminate any instances of racism immediately they occur and prevent them from recurring. The Minister continued that no amount of abstract ideas will resolve the problem, must begin to focus on creative, practical, simple, accessible methods and solutions that will resonate with the masses of our people. The Minister called for outcomes that will yield the material benefits necessary for South Africans living with the consequences of past injustices to go forward. He believed that only then would there be peace between the races. Bearing this in mind, it should be noted that there is a hate crimes bill currently before Parliament, and that while the original intention of the hate crimes bill was not to criminalize hate speech, the position is now being reconsidered, having regard to the clearly outrageous racism that South Africa is presently experiencing. The Deputy Minister of Justice and Constitutional Development has indicated that the government is exploring ways to strengthen crimen injuria provisions, that is provisions it's almost the criminalization of defamatory statements. Crimen injuria is the criminal equivalent of making defamatory statements for which there could be civil consequences. So he's looking for ways to strengthen crimen injuria provisions in the existing legislation to provide for the penalization of blatant racism. In other words, racism in its blatant forms will become a criminal act for which criminal proceedings against the offender can be instituted. The Deputy Minister noted that the right to freedom of expression is not absolute. Remember, the defense raised by certain of these perpetrators of racist statements was that they were merely expressing their right to freedom of expression. The Minister has given notice that the right to freedom of expression is not absolute, and what he has said is that freedom of expression may not impinge on the right to dignity. Remember, both the right to freedom of expression and the right to dignity are rights that are ensconced in the Bill of Rights in our Constitution. The Deputy Minister pointed out that in terms of South Africa's constitutional framework, government has an obligation to legislate for tolerance. It sounds excellent. Legislate for tolerance. The Hate Crimes Bill will seek to address crimes driven by prejudice. A proposed national action plan for combating racism, racial discrimination, xenophobia, and related intolerance was released in January 2016. It is available on the Department of Justice website for anyone who's interested. And that action plan indicates that the draft bill will introduce a definition of hate crime to be shared amongst all those involved in the criminal justice system. Once the Hate Crimes Bill comes into operation, it is expected to provide investigators and prosecutors with additional tools for holding hate crime perpetrators accountable and go some way towards mitigating insensitive or inappropriate behavior among police, healthcare, and justice officials when dealing with the victims of racism. The Minister seems to indicate, and we probably will all agree with him, that victims of racism do not get the assistance or the aid that they need, and they are left largely on their own at the moment. Okay, then there are also reforms ahead for education and skills development. I'm not going to go too much into that at the moment. You will have the slides, but this also deals with the rather contentious Protection of Investment Act. Our Minister of Finance has said that the Protection of Investment Act in no way stands in the way of selling South Africa as a safe investment destination, noting that it would be foolish for a government to do things contrary to its objectives. A lot of people have raised all sorts of objections against the Protection of Investment Act, and the Minister was merely trying to indicate that it is not as bad as people seem to believe, and that certainly government would not do anything that would be contrary to the interests of South Africa. The President has already assented to that act, of course, but it will only come into operation on a date to be determined by the President by proclamation in the Gazette. The stated intention of the act is to achieve a balance of the rights and obligations of all investors. And I think that's enough about that. One should be mindful of the act, follow its process, see what eventually happens, and we will certainly be giving CPD updates on the progress of the act in due course. Final thing I'm going to talk about quite quickly is the electronic deeds registration system that is imminent. A draft deeds registries amendment bill, which is aimed at facilitating government's land reform initiatives by enabling the electronic registration of a large volume of deeds, is presently in the offing. The memorandum on the objectives of the proposed new statute envisages that these processes will be expedited so as to fast-track land delivery. We all know about the problem of land delivery, land registration, and the need to ensure equity where the land question is concerned. The board, the EAAB, is actively engaged in the title deeds restoration project together with the Department of Human Settlements, pursuant to which it is hoped that title deeds will be given to all persons who have received governmental housing. This will enable those persons to own the property, have full title to that property, use the property not merely as a roof over their heads, but as a source of wealth, and also create a secondary housing markets in hitherto neglected areas. Very, very important. And we believe that the draft Deeds Registries Amendment Bill will go a long way in assisting in this process and in significantly enlarging the estate agency sector in South Africa. The draft bill provides for the registration of conveyances as authorized users of the envisaged system, which would make use of digital signatures and enforce the payment of fees. The memorandum accompanying the bill notes that the computer system for maintaining the electronic land register, remember, electronic land register, something that is so incredible and that has been so needed over the last couple of decades, is already in place. And it also refers to a number of imperatives to which the draft bill is expected to respond, including a link to government's electronic cadastral information system. Remember, cadastral information system is a system of creating diagrams of land. So once a diagram is created, that land can be transferred to a purchaser or to an owner or to someone else. There's decentralized service delivery at points of need, consolidated rationalized registration procedures across pre-1994 territorial jurisdictions, and registration capability for other forms of land tenure that government may introduce in the future. That is quite interesting. other forms of land tenure that government may introduce in the future. We will keep a beady eye on that, see what other forms of land tenure can possibly be introduced, and ensure that estate agents are kept apprised of developments in this respect. I thank you for having listened to this presentation. Hope that you have learned something of value, and hope that you are now able to answer the questions that are going to be posed so as to enable you to obtain your verifiable CPD points. Thank you so much.